at the Administrative Procedure Act, Title 5 of the United States Code. And this is what all government agencies, and that means anyone who's acting in the capacity of a government agency. So again, even if we're settling our debts, dealing with the CFO of different companies, those are government positions, and he falls under the definition of a government agency. So he is also required, he or she, that CFO, is also required to adhere to the provisions set forth in the administrative procedure. So I made a couple highlights in here. Here's a particular thing I just highlighted because I found this interesting, and you can just use this as fuel in your responses and when you deal with these different agencies. It says a final order, opinion, statement, or policy, interpretation, or staff manual or instruction that affects a member of the public may be relied on, used, or cited as precedent by an agency against a party other than an agency only if 1. It has been indexed and either made available or published as provided by this paragraph, or 2. The party has actual and timely notice of the terms thereof. So when you're dealing with somebody that's standing in the way of your remedy and they're trying to make up policies, or they have no proof of what they're talking about, you can work this right here in your administrative procedure. I just put a note here, and it says, this means the agency would need to provide you of its claim that you had timely notice before using any order, opinion, or interpretation against you, essentially. So that's just something I highlighted in here. I'm going to put this document on the website with the highlights. Let's see what else I've highlighted in here. No agency may require advance payment of any fee unless the requester has previously failed to pay fees in a timely fashion, or the agency has determined that the fee will exceed $250. Okay. Okay, now here's something here, Section C. Notwithstanding any other provision of law, the defendant shall serve an answer or otherwise plead to any complaint made under this subsection within 30 days. So there you have it. They have 30 days in accordance with the Administrative Procedure Act to correct the records or answer you based off of what you file. So that's why I always say it's good to start out in your initial correspondence by giving them 20 days to respond. And then when they don't respond in 20 days, then you can give them the notice of fault opportunity to cure, giving them an additional 10 days. Because then you have your default and your notice of fault opportunity to cure, and then you have another default that goes into the judgment. And at the same time, they've had a total of 30 days. So you see how that works. Here's something else interesting. The court may assess against the United States reasonable attorney fees and other litigation costs reasonably incurred in any case under this section in which the complainant has substantially prevailed. Now, that's just an interesting piece of information. We're not doing the administrative procedure so that we can take it into court. At least, well, I don't do them so that I can take it in court. I do them so I can create enforceable claims, so I can foreclose on them if I have to, if someone continues to trespass. But if you have to take this into court and make your administrative process a part of your counterclaim, right here it says that you're entitled to attorney fees, litigation costs, etc., etc. Let's see. Here's something else that's interested. So if you do have to make your administrative procedure a part of a court hearing, of course you need to be in the district court, the federal court. Special counsel shall promptly initiate a proceeding to determine whether disciplinary action is warranted against the officer or employee who was primarily responsible for the withholding. You see how they're talking about the withholding? The person that's withholding is the person that's prejudicing your rights. Okay? The special counsel, after investigation and consideration of the evidence submitted, shall submit his findings and recommendations to the administrative authority of the agency concerned and shall send copies of the findings and recommendations to the officer or employee or his representatives. The administrative authority shall take the corrective action that the special counsel recommends. These are just interesting things, again, that you should be aware of. Okay, this deals with the timelines. Each agency, upon any request for records made under paragraph 1, 2, or 3 of this subsection, shall determine within 10 days, except Saturdays, Sundays, and legal holidays, or in legal public holidays, after receipt of any such request, whether to comply with such request, and shall immediately notify the person making such request of such determination and the reasons therefor, and of the right of such person to appeal to the head of the agency any adverse determination. So that means when you present your claim, I know a lot of people is looking at this and say, well, this is talking about a request for records. Well, if you do a settlement on an account and you're requesting an authentic statement of account to certify that the balance is zero, that's a request for records. Now, again, what this section that I highlighted here is telling you is that if for whatever reason they don't want to comply with that, then they need to let you know why they made the determination and what policy or procedure from the corporation are they acting from? Where do they get their authority from? And if they don't give you any of that within 10 days, then by tacit acquiescence, they've accepted, they accepted your contract. But essentially, like I say you give them 20 days in the beginning. So 10 days go by, now they're locked into it. 20 days go by and there's no response, then notice of fault, opportunity to cure, etc. It basically says they can, request time. In unusual circumstances as specified in this subparagraph, the time limits prescribed in either clause or clause of subparagraph A may be extended by written notice to the person making such request. So they had to send you a written notice if they're trying to extend the time. Any person making a request to any agency for records under paragraph 1, 2, or 3 of this subsection shall be deemed to have exhausted his administrative remedies with respect to such request if the agency fails to comply with applicable time limit provisions of this paragraph. That means if they don't get back with you and the timeline allowed, then you have deemed to exhaust your administrative remedies. So, nobody can say he didn't exercise due process before he filed this lien or before he took some other form of enforcement action, because if you've done your procedure in accordance with the Administrative Procedure Act, then you will have been deemed to have exhausted your administrative remedies. All right. Upon any determination by an agency to comply with a request for records, the record shall be made promptly available to such person making such request. See, promptly. Any notification or denial of any request for records under this subsection shall set forth the name. Listen, so if somebody's going to deny or they're going to withhold your remedy, they have to provide their name, title, position of each person responsible for the denial of such request. See, they're giving you the information that you need to hold them accountable, and they're required to. So just know where this is. So when you start requesting that information, who in the organization made the authority to deny me such a request? I need his name, I need his title, I need his position, I need his supervisor, as he's required to give to me in accordance with Title V of the United States Code. There's a lot of good things in here for you. Now, each agency that maintains a system of records shall, upon request by any individual to gain access to his record or to any information pertaining to him which is contained in the system, permit him, and upon his request, a person of his own choosing, which you might want that to be a notary, to accompany him to review the record and to have a copy made of all or any portion thereof in a form comprehensible to him, except that the agency may require the individual to furnish a written statement authorizing discussion of the individual's record in the accompanying person's presence. And they're also required to permit the individual to request an amendment of the record pertaining to him. Now, basically, this says after you review the record, you can ask them to, you can demand actually that they correct or modify the record, and you can give them 10 days to do so. And if they refuse to make the correction, again, let's read right here. Okay, it says once you request that they modify the record, they have to make any correction of any portion thereof which the individual believes is not accurate, relevant, timely, or complete. Or, and this is if they don't want to make the correction, they have to inform the individual of its refusal to amend the record in accordance with his request, the reason for the refusal, the procedures established by the agency for the individual to request a review of that refusal by the head of the agency or an officer, etc., etc. So again, when you request that they correct a record, they have to either do it or they have to respond giving you the reason why they're not going to do it. And again, if they give you the reason why they're not going to do it, it has to be something that has already been established by policy in writing, as we learned earlier. And if it doesn't, then again, you have a withholder on your hand, and you need to structure your process to make him liable for your interest in the matter of which he is prejudicing by his actions of withholding. Okay. Hope this isn't too complex for you guys. And once you get in there, and if you go learn how to do the administrative procedure, it'll all make sense. You just got to get in there and do it. There's going to be samples on the site. So again, this is the way that you fix things without having to go to a court, without subjecting your body or your vessel to imprisonment and all the other commercial processes. Now, here's one more very interesting thing, and something that I pretty much learned. Persons entitled to notice of an agency hearing shall be timely informed. So you can request an agency hearing if you're dealing with a government agency, and I assume this is even for a debt settlement. Request an agency hearing, and they have to make you timely informed of the time and the place and the nature of the hearing, the legal authority and jurisdiction under which the hearing is to be held. Read about this because there's a whole procedure laid out to where you can have an agency hearing with an administrative official there. So you can perfect an administrative procedure first so you can have your evidence and then call for an agency hearing to get the issue resolved right there. Just read through this, some interesting things in there. And I'll kind of leave it at that because this video has gone long enough. But make sure you visit thctrust.org so you can learn how to do the administrative procedure. And I welcome you to send me any emails of specific requests or things that you don't understand. And I'll have more than enough samples and more than enough information covering the administrative procedure at www.thctrust.org.